Good afternoon. Um, Welcome to this webinar. We're just a couple of minutes after 2. So I'm going to begin in a few moments. I can see that we've got a good attendance. That's great. I hope you should all have on your screen me and also to one side or in the main focus of the screen, the first of my title page for my slides, which we'll be discussing this afternoon. Just a couple of announcements. As you heard when you logged in, probably this will be recorded, so there will be recording as well as my slides to circulate afterwards. Also, if you have any queries, please use the chat function below. I think there's a Q&A section, but if we just stick it in the chat, that's the easiest place. I've received some queries already, so I can sort of address them at the end as well, hopefully. That is just 3 minutes into 2, so I'm hoping to start now. It's good to have so many people on the call. I know it's the first day for many people of the school holidays, so it's great to have such a large turnout. That's excellent. But the focus of this talk, and the way I've titled it, is that it's about the challenge that local authorities with ACV responsibilities are facing. I hope the talk will have wider relevance. Spoiler alert, the pressures upon asset owners from this reform are very significant as well, and I will be talking about that. But this talk is really framed to give you a sense of the administrative implications of this. To that end, I will be addressing in the first third to half of the talk the current regime to frame the matter. From your responses to our initial question, I know that approximately half of you will not necessarily have or limited experience with ACVs, so I hope that's helpful to you. Those of you who have greater experience with ACVs, I beg your forgiveness. I hope you'll find it useful that we just frame what the new system is doing in light of the current system. And I think it's probably useful in that regard because it helps to frame what's going on. Anyway, let's go to my first slide. This is just my agenda. As you can see, where we got here, what the issues are, what's happened with the system, expectations and reality. Then the current regime, you can see my run through the current regime, the proposed system. And what I would say is, if you look at those subheadings on the proposed system, I know title page, what use is that to you, but what I would say to you about the subheadings on this fourth main bullet, the proposed system under the English Devolution Community Empowerment Bill, so don't say that too quickly, that proposed system, all of those subheadings put burdens on local authorities. They all introduce new issues that local authorities are going to have to deal with. So that's a way to frame it. Not a great way to frame it, I'm afraid, but that's the way it's going to be. Okay, let's talk about the introduction. That little picture in the top corner is the Venn diagram of my life overlapping. That was the Daily Mash doing a story about ACVs, which was a high point for me, taking the mickey out of the system, rightly or wrongly, and we'll get onto that, I'm sure. As most of you will know, the Asset of Community Value regime was brought in by the Localism Act in 2011, one of the flagship acts of the coalition government. If you'll have engaged with the Localism Act, if you are in local authority work, you probably have in private practice too, and I've described it there as a rag bag because it is compendious and it has lots of subsections, and there's a whole chunk on assets of community value, but as you will know, there's many other things captured under it. A piece of land or building that is an ACV under the current system, what it amounts to is an owner's right to sell being delayed. And the key bullet point here is that fourth one. Now, the ACV regime created a right to bid, not a right to buy. If you've seen any case reports from the tribunal, the actual headline, the header note of the case report talks about right to bid. That's what it's come to be known as within the judicial system. And that, the fourth bullet point, is the key to why the system is changing. So let's move on. So where does it all begin? I'm going to take you back before the coalition government. You may remember this. When in opposition, the Conservative Party came out with their green paper called Open Source Planning. That was the buzzword of that particular time, so it was taken into the title of their document. It's a bit like putting AI on the front of everything nowadays. Back then, it was open source. So this was open source planning. Actually, if you read open source planning, it's not about ACVs, but it's about this localism agenda. And at the same time, Caroline Spellman, who was then the Shadow Secretary of State, you will recall, came out with came out and introduced this concept of community groups having first refusal on buying public assets that are being closed down and the right to a fair price. And you'll remember issues about loss of community, loss of pubs, loss of post offices, those classic community assets predominantly in rural contexts that were being lost. And you can see also there a headline from the Daily Mail at the time. And I often refer to the concept of Daily Mail planning, the kind of stuff that gets in the Daily Mail, whether it's people hiding their place inside a hay bale, or, this was really populist stuff. Let's create this community right to buy. Actually, a right to buy is a very significant imposition upon the owner of an asset. Now, I hope I cause no offence. I'm somewhat flippant with that slot, in that slide, but I think it is useful in just recognising how antithetical that view of ACVs, a right to buy, can be to seen in light of the traditional right-wing political view on property and the rights of ownership. The right to buy for it being provided to any group is somewhat curious in that respect. In terms of matter of commentary, not sure if this will assist you, I think it is quite interesting that this ACVs represent interesting tension, because traditional right-wing political theory is very concerned about the right of property owners, but it's also popular right-wing politics has always had a concern with what we would colloquially call NIMBYism, and there's a tension there. That's what ACVs are about. Much of the planning system is about people through the planning system as third parties trying to engage with other people's right to do stuff. And the ACV regime is much like that in respect. It's not the planning system, but it has parallels. So think that that's a useful viewpoint to see what's happened here, and where it gets us to my next slide, which is the concept of the right to buy. I just want to make a sort of frame this ahead of us from what we're going, because, as I say here, spoiler, this is foreshadowing for what's coming. The right to buy is novel context in the English system of law. You will be, I'm sure, different professional contexts, aware of, engaged with, perhaps worked on the compulsory purchase system. Well, anyone who has knows that it is labyrinthine and complex. Matters take significant amounts of time. They go through the system slowly. The compensation system follows afterwards, with often multi-year matters before the Lands Tribunal. So we have an existing system in England that deals with when land is alienated from an owner, and it is very interesting, just put it that way. So it's very interesting that we had this framework where, in opposition, certainly the Conservatives, before they came to coalition, were looking at a right to buy, which would of course be so much of an imposition when we have that wider context of how compulsory purchase works. As I say in my final bullet point there, it is novel what was being suggested, the right to buy, and what may be coming forward, because of course it's not simply like our normal compulsory purchase system where the purchase takes place by an emanation of the state, and they may then sell on to a developer, but it is becoming the state taking property off the private owner. The right to buy, and what may be coming in the new bill, is a right to buy for a private buyer. It is the forcing of sale from one private party to another. So it's unusual. It's intellectually different from what has occurred previously in English law. And I say English law because, of course, as you know, the Scottish system of law has always been different. And in Scotland, they have had for a number of years now the community right to buy. And certainly, commentary on what coming here is looking to that as what might be the way things pan out or the system may function. So it's worth being aware of that in the background. Okay, so what is the problem with the current system that's led to what is going to be a significant change with the new bill? Well, the difference between what was promised in that Daily Mail headline and what was delivered is very dramatic. A right to buy and a right to bid are two very different things. Here they are sort of paraphrasing of things I've seen in documents over the years. So here I see, submissions to a planning appeal might be, we've got an ACV on this land, so as part of this planning application for something completely different, the Secretary of State needs to order the sale to the community, or expectations were created by the system. very significant expectations on the part of local communities and the groups that form to make bids. I've read different estimates, but generally, the range is fairly narrow, of between sort of 1.5% to 2% of listed ACVs have actually come into community ownership. So we've had thousands of listings, and we are talking maybe over 100, but not much over, actually come into community ownership. So that is what has the system delivered. I've been working in this sector, this area of law, since it came in, and I have to say it's very reasonable to say that it's hard to see the impact it has had in the practical delivery of these community assets. And a classic example is, you will see, and I've read it when in some jobs I've not even been involved in, I've just read it in the local press where I live. Oh, we've got an ACV listing, and there's a headline in the local press celebrating that. And then, 9 months later, that same concept of community value is being torn down by a developer, because the effect of the listing is not led to what was expected, the expectation that people had from the introduction of the system. I act privately and publicly in this area, but I have acted for private clients who have said to me, as a result of the system, I would sell it for £1 to anyone else except for those, insert expletive, because actually the system creates quite a lot of tensions between parties of the owner and the nominating group. And I don't think it has probably practically had the effect of encouraging or leading to cooperation, because it is, as we know, a right to bid, not to buy. Okay, so what can be listed? Just a few examples as we're getting the system in place. The classic, the definitional ACV is the village pub. Another classic example, village shop, post office, village halls. You might see a theme here, but nonetheless, sports stadiums. I've acted in a couple of different sports stadiums, and we know from the case law that's entirely feasible to list a sports stadium. Probably not what was in the framing of anyone when they were framing the initial legislation. Allotments. I've acted in 2 or 3 allotment cases. Woodland, just public space like that people, not private space that people want to enjoy in a public manner. Golf courses, quite a common matter to be listed. And my final example of theme parks. Often attempts to list particularly village car parks, because a camped village can be a very significant asset of the ability to find somewhere to park. So that's just a few examples. And then here I'm going to take you to the current Section 88, which is the definition of what an asset of community value is. I've provided it here full. This is the current section that sort of governs the regime, and I've highlighted for you in red the sorts of key phrases that have been the subject of litigation and been the subject of the case law and we'll discuss those. But you see it's split into, you've got what's called the current use provisions. Those are subsection 1. And you've got the past use provisions, subsection 2, where an asset has gone out of use, a pub shut down, some things are not shut down, but you can run the test through subsection 2 instead of subsection 1. And I would frame it this: Section 88 is fundamentally what any decision maker, whether it's the first tier tribunal or the local authority, is having to think about when they make their decision. It is not other things. It's not the risk of having to pay compensation as a local authority. That's not a legitimate consideration under the regime. It's not whether this regime is an effective use of resources. I've seen appellants write and say, well, this regime's stupid, so you shouldn't be doing this. It's not in the Act. It's not whether actually any future disposal would be exempt from the provisions anyway. I've seen that submitted, so don't even bother applying the test. It's not there either. It's not that there are other community uses like that. It's not, well, there's 3 other clubs in the village, so what's your problem? Or there's loads of golf courses in this area. That's a very common submission, but it's not there in Section 88. And it's not, oh, well, actually this business is thriving, it's not at risk, so why bother listing it? These are all interesting points, legitimate concerns, but they're not there in Section 88. So the fact of the matter is, Section 88, the only other area that tends to be live in litigation, or can be, is the eligibility of the nominating group. I'm not going to get into that today, but dominantly nominations can the right lies of parish councils, and you often see that's where most come from, but also community groups can also make them. And there's various provisions in the regulations to govern what is a relevant group for that. The litigation on that was all pretty much early in the process. So it was in the first few years of the regime that landowners went, oh, hold on, who's this group to nominate? Have they met the tests? Particularly, one of the most notable case in that is Camera. Camera as a national organisation for the campaign for for Real Ale. How does it function? Is it a local group, or does and then it's that was subject to litigation, but really most of that litigation is dead now because it got dealt with in the early stages of the regime. And also, fundamentally, if you win on a nomination point, you're really just storing yourself up for another fight in a few months' time when the right kind of constituted group makes the nomination. But as I say, the core of the issue on the current regime is the application of Section 88. Great. Okay, let's move on. So this is some of the case law that stems from Section 88. I know from the queries we're planning ahead of time, people were keen to understand. Somebody said, is there case law? I've not seen very much. There is surprising amount of case law on it, on different parts of the Act, specifically Section 88, and different concepts within it. So this is referring, my headings here refer back to my red marks on the previous slides, just so you can see the kind of key phrases that have been fought over. Building or land, not ancillary, what's called the realistic to think test, which appears in both of the subsections of the Act, and the recent fast-food component. So I'm just going to take you briefly through these. As I said, I gave you some examples a few minutes ago of the different kinds of things that can be listed. There is many different things that I've given you, sort of 8 or so, but there's lots of things that can be applied for. The concept of it, the thing that you are applying for, the use that you want to be listed, the reason you're listing the piece of land can't be ancillary. That's from the Kassam Stadium case. That's the stadium in Oxford. So that's very early in the regime, 2014, for that in Oxford City Council about the Kassam Stadium. And the example I would use to understand the concept of whether something's ancillary or not is there in my EG. A car park can be listed, but you can't list something because of its car park. So I've seen cases where people apply to list the car park of a village pub because that car park is brilliant for the school run for the village. So the village school is, busy place, lots of kids arrive in the morning, and we all use the pub car park and the landlord doesn't mind. Let's list that as an asset of community value. That's ancillary. That's not ancillary. That's not part of the nature of being a pub. Now, a pub car park, which is there as part of the pub, is definitely within a listing. And we're going to talk about why that's interesting in terms of some of the changes that are coming. But there are components of a use that are all part of them. So, for instance, the car park to a pub is ancillary to the people coming, hopefully safely drinking and not driving. And also, other parts of the pub are not doing a community thing, but they are important. So, the beer cellar, you don't have a pub if you don't have that. Okay, none of the public are in there having social well-being in the beer cellar, but that's part of it. And there have been case law trying to do that, what's referred to in the case law as salami slicing away. Well, can I slice off this bit because it's not really a community thing? And the case law from the tribunal is, no, we take it around. There are things that are just, we're not going to engage in that salami slicing. Now, the thing that is probably the most hotly contested is the realistic to think test, which is when something is accepted as being a current past community asset of community value, the next part of the section is that you have to carry out a realistic to think test about whether it continues to be. So 88(1)(b), current use in the future, is it realistic to think it could be? Subsection 2, a recent past use, is it realistic to think in the next 5 years it could be doing a community well-being role again? So that's what the realistic to think test is about. And I'll just point out here, the future realistic to think community use doesn't have to be the thing that it was. So whether a pub transmogrifies into a community centre where there's also Zumba in the function room, or whether a post office becomes part library, part post office, as long as there's community well-being, it doesn't need to be the same thing. There doesn't need to be that continuity. But the key case law I refer to here on realistic to think is Banner Homes. That was, as you can see, unusually a Court of Appeal decision in this area, and it determined that realistic within the legislation had that meaning of not fanciful, and that put a very low threshold for the realistic to think test. It dropped through the floor. And that has been the real challenge to anybody opposing a listing since, is that the realistic to think test is not a very high threshold. Then we have an interesting decision from 2020, Farsberg. If you want to remember that case, sounds a bit like Carlsberg, the easiest way to do, especially in a pub-based regime. This was a paper without hearing first-tier tribunal decision by Judge Finlay, who is very experienced in the determination of ACV appeals. And Farsberg, if you look through the case law, there have been various people trying to understand and push at what this not fanciful meant. Like, well, yeah, okay, but is this not fanciful? Or how poor or thin or weak does a nominator's ideas for the asset have to be before it becomes fanciful? That's what you can see in all the case law. I've written those cases. I've also been involved in those cases on the other side. And we get to Farsberg and we get this decision from Judge Finlay, and she says, realistic means a sensible and practical idea of what can be achieved or expected. There must be some indication that aspirations are realistic. So it requires of the nominating group, or the evidence before the tribunal of the nominating group, that there is something going on. There's been some, as it says, sensible, practical idea. Now, this decision, when it came out, was very striking, and in any pleading subsequent to Farsberg, suddenly it was being thrown in by owners because they were backing against Banner Homes as very low threshold. And I would give my honest opinion that I've struggled to see who they worked together. But what we have, and it's a really useful decision, it's a very long decision, but it's closely argued and debated, is Dragonfly from Brighton and Hove. Dragonfly is a decision from last year, and it is an upper tribunal decision. It's not Court of Appeal, but upper tribunal, so it binds the FTT, the first tier tribunal. And in that, Farsberg is discussed, Banner Homes is discussed as well. A lot of case laws discussed, which is why it's an excellent decision, because it really gives you a good survey of where the jurisprudence is just now in this area. And in Dragonfly, the judge does swear the subcon, says how Farsberg and Banner Homes are not in conflict. And that's where we are. That's the current position of how those two tests can interact. As I say, when I read Carlsberg, I struggled to see how it worked with Banner Homes, but that's why I'm not an upper tribunal judge. And we do have an excellent decision in Dragonfly, which is, if you are working in the sector, it's probably a really good first place to go on most things, because it's one of those modern judgments you get from the bench where it really summarizes things for us. Okay, realistic. The gloss on realistic that we are here about is that realistic is not the most likely. So realistic can entertain a number of different outcomes, and that's an important decision. So, Landon McGreen, well, I'm doing this thing. And you'll often see in decisions the tribunal say, well, we see that that's your intention, but it's not unrealistic that this could also happen. And so it's not a what's the balance of probabilities thing that was most likely to happen. It is just a number of outcomes can exist. Recent past, there was a number of cases run where the meaning of recent past, which is section 88(2)(a), was challenged. Well, what does that mean? And some people tried to say, well, it must be like the 5-year future test. So, well, can it come back in 5 years' time, which is in section 88(2)(b)? And that was decided no, it's not. Recent past is deliberately vague. It's to give you, and recent past can be different for different things. We have a country with assets that might be hundreds of years old, or it could be, a village shop that's only been there a few years. The recent past in those contexts can be two different things. So the case law has determined that recent past is deliberately left like that, because in the context of the matter being pursued. Now, this final point is not within section 88 explicitly, but it is a very important point to know from the case law. It's an accepted principle that, despite it not being in the Act, it is possible to partially list a community asset. So you get the application in, there's something wrong with, you think the plan's wrong, you think the plan's gone too far, it shouldn't include this space or that space, and you, as either the tribunal, which has done it in case law, Gulliver's, or now listing authorities, local authorities dealing with it, you have the ability to amend and partially list. That's not in the Act, but the tribunal said very reasonably, hold on, if we don't take this on and we don't try and amend this listing to make it work, we're going to give a judgment that says all of this stuff should be listed but not that, and all we're doing is provoking another round of applications and litigation. So that's where the partial listing part comes from. And court has no higher court, and nobody's challenged it because I think all the players in the regime realize that that's a useful and important ability of the decision maker. Let's just talk what has been the effect of listing thus far. And I would always say there's basically two areas that the listing does something about. One is fundamentally from the Act, it creates the moratorium structure. We're going to talk about the moratorium for a bit, but moratoriums are not our RIP in the new system, but it's worth knowing about here. So the moratorium provision delays sale. It creates an initial 6-week delay. So I give notice as a landowner that triggers 6 weeks, and within those 6 weeks, a community group can come forward to express an interest. And just for the current system, do note that that is the indefinite article. It is a community group. It doesn't need to be the one that nominated, and that's very important in the current system. And spoiler alert, is going to change. If the community group comes forward and says, we're interested, that initial 6 week converts into a full 6 months. So that'd be an extra 4.5 months are added, essentially. Just so we're clear about that. It's not 6 weeks and 6 months, it's 6 weeks total. 6 months total, pardon me. Okay, so that's what it does in terms of the Act. The other matter is how it impacts on the planning regime, where it has been found, and we'll talk about that shortly, to be a material consideration. So what does that mean? It's very significant. It can be significant planning decisions. We'll talk about what's actually led to. And I just note here that when you go on the list, the effective listing is to be on that list for 5 years currently. And that's the current provision, Section 87, not a change provision. Okay, moratorium, Section 95 currently, and which is Section 86K in the new proposed bill, because the proposed bill is going to insert a whole bunch of provisions into the existing Localism Act, all under the number 86. We'll get onto that in a moment. So, as I say, the owner must notify local authority if they want to enter what's called a relevant disposal. And then, as it says here, you've got this interim moratorium period of 6 weeks, and then a community group can turn that into 6 months. Now, then we have the relevant disposal conditions. You can see that in my middle point here. That's the notification, the period has expired, and then you're still within your 18 months. So if you're an owner who wants to sell, you've notified, you've got through the moratorium period, whether it's 6 weeks or 6 months, and then after that, you have 18 months of grace to carry out your disposal before you would be into a new round of triggering. That's how it works. Then Section 95.5 is where some of the really interesting stuff happens. That's the exceptions to the moratorium provisions. And that's where Section 86K is interesting, because it sort of carves out things that aren't affected by the system. So 86K and 95.5 have some degree of overlap. The first half of 95, which is my moratorium, will disappear because there won't be moratoriums under the new system. It's a sale system. But that's 95.5 is where landowners are looking for most of their options to find a way out of the listings regime. And in that regard, I've highlighted Section 95.5e, which on the current system is eminently memorable because it's 95.5 and an E. Sadly, that's going. But 95.5e is the partial listing exception, which is the concept that a piece of land that is partly listed in one corner but not in the other, you can't delay the sale of the bit that's not listed because something else is listed. So that partial listing exception has been very useful in my experience over the years to defeat the moratorium provisions, because you say, yes, I know I'm listed in this corner, but this bit isn't, and you can't delay my sale, so sorry, the moratorium doesn't apply. Which is also relevant to planning, because and you say, well, how material is the listing in a planning case when the moratorium won't kick in, so there won't be an opportunity for it to fall into community ownership through the moratorium provisions because they don't apply because of partial listing. I'm conscious I'm going quite quickly, but I hope we're getting through it and helpfully so. I don't see anyone in the chat saying, please slow down, you crazy man, so that's a good sign. Okay, and then you'll see I've just got a note there, Section 97 requires the intention to enter a disposal to be listed, which obviously makes sense because it needs to be publicly available for community groups to be involved with it. Okay, let's move on. Right, is the ACV status a material consideration? This is the quote from what's called the non-statutory advice note on ACVs that came out in 2012. The fact that the site is listed may affect planning decisions. It is open to local planning authority to decide whether listing as an asset of community value is a material consideration if an application for change of use is submitted. So, as I say here, that's not true. That's just that, as we know, if we've practiced in planning at all, and I'm sure many of you have, something as a matter of law is either material consideration or it is not. It is not Schrodinger's material consideration according to the non-statutory advice model. So the upshot of that is that consistently, since the regime came in, planning decision makers, whether that's councils or inspectors, have just said, yep, ACV is a material consideration. Being a material consideration, of course, is just a matter of weight then for the decision maker. And as I've said, there are arguments to be made in different directions about how much weight should be given to the regime. And frankly, in most planning decisions, if it's a planning appeal, there's an ACV listing, there's usually community asset policy within the local plan anyway, saying we will protect, enforce, conserve, look after our community assets. So even without the ACV regime, there's usually a material planning consideration as part of the local plan saying that this is a thing that matters. Anyway, so maybe a little bit short shift there on my part, but I think it's an accurate reflection of how much impact it's really had in the planning system. Okay, this is just a little talk through process. First thing I know at the top there, the listing, that application of Section 88 is a factual assessment of the circumstances of the asset, the site. It's not a policy decision. So, and I've just referred again to the concept of fluid certificates in the planning system that are also classically an assessment fact. And authorities that I've worked with in the ACV regime often put the ACV part of the assessment at least into the legal department, just as they do with certificates, because it's about the factual assessment of evidence as much as anything else. In fact, not as much as it is about factual assessment of evidence. It's not about what's our feelings about community assets. And so I make the note here, that's one reason why it's not a great idea for it to be a member decision, frankly. The other reason is that the regime has the internal review provision, so that you go from the first decision, and before you go out of the council into a tribunal decision, with all the costs, you have an internal review inserted. And the regulations, I've referred to them there, the 2012 regulations, they provide that internal review from the officer who decided to list must go to an officer of appropriate seniority. And as I say, I've had the benefit of working for a number of councils who've wanted to be involved to assist that senior officer. I'm very happy to do that. In my experience, tends to be a very senior officer, so, as I say here, deputy chief exec level. And the point I make here is that's another reason why you probably don't want the original listing decision to be made by members, because it creates a real tension. Because what the law requires is that the review is carried out by an employed officer of the council of appropriate seniority. Well, it can cause a constitutional problem for an authority, because that means that you would have that senior officer potentially overturning the decision of their elected members. Let's just carry on. You can see some questions starting to appear. That's great. I look forward to answering them as we get on. Let's get through this. That's the review process. As I say, listing, review, then to the tribunal. And this final bullet point on this page is making the point that the nomination is technically just the preserve of the nominator. If you look at the way the legislation is drafted, it's framed as if it's just a nomination to the council, and the council deal with it. And similarly, the review currently is just framed as a process for the asset owner. It's their chance to get in on the process. And then the appeal is also the asset owner's appeal. But in reality, in the cases I've dealt with over the years, most authorities have seen that that's not very practical, actually. Before you decide the nomination, let's just hear from the owner. And similarly, when you get to the review, okay, it's the owner's review, but what do the nominator say about it? And then when it gets to the tribunal, it has been my entire experience that the tribunal will always let the nominating party engage as well. They will make provision for them to become formal parties to present evidence. So whilst the formal drafting of it is a sort of switching sides, actually, in reality, the system tends to work with every party engaging each stage. So if you are a local authority dealing with it, and I have advised on this on reviews, for instance, just engage with the nominators, because it's just relevant for getting the right information in front of you for the decision-making process. And here's just a little summary of that appeal process: nomination, refusal, If it's refused, the only option currently open to a nominating group is judicial review. There have been some, not many. If it's listed, then it becomes internal review, as I say here, and that's the process that is in the hands of the owner. They can press that currently. And that by Section 92 is a de novo, to be all lawyerly. I'm using the Latin for no good reason, but that is a new matter that is looking at it fresh. Then if the listing's upheld, it goes to the first tier tribunal. And that was previously seen to be a de novo decision, but I reference in this slide Newton and Derbyshire Dales, which is a case of a year or two ago. And on that, I think. And also that's relevant to how we understand that. So let's just get on with that. So Derbyshire Dales, this is a useful slide. It's not on the current or the proposed regime, so I'm going to be quick about it. But you will have this slide. It's worth understanding. When this stemmed from the Begum decision, which you remember was the young woman child who found herself in Syria and found herself also unable to return for administrative decision-making reasons by the government. I'm not going to go into it more than that. That went all the way to the UK Supreme Court, UKSC, and that in fact it was engaged with the system of administrative appeals works. Now, on Newton and Derbyshire Dales, on the first day of the hearing, and in fact, I was on that matter for Derbyshire Dales, and Simon Bird KC, who often sits as a judge in this, was acting for Newton. It was by Judge Neville, well, how does Begum affect these can I have here? Submissions, is it de novo or is it something different? And so submissions were made by both parties. In fact, Mr. Bird's Casey and myself both said it's de novo. Let's keep it de novo. That's how the system is functioning. We made our submissions, and the learning groups disagreed with both of us. So Judge Neville held on that. No, it's not de novo a hearing. It's involving an inquiry about whether the review decision was wrong. It's not what in aspect like judicial review is. It's not, well, what was the decision at the time? But but you do have to be giving weight to that initial decision. It is a first tier tribunal decision, but it appears to be being followed in the case law. It's not binding as a first tier tribunal decision on other tribunal decisions. But as I say, Judge Neville is now in the upper tribunal, and it appears to be being followed generally. If this continues, we've got built in, and we'll get onto that in a moment. But if this were to continue, what does that mean? It makes, because you're reviewing the internal review as part of this process, it means you need to be more alive to how you carry out your internal review, because that's going to be the battleground at the first tier tribunal. It's not going to be a new fight at the first tier tribunal, which is what's been up until now. It's going to be a review in some degree of your internal review. And that means you want to be more careful about how your internal review is structured and reasoned. It also means that owners, post Newton, need to really engage with the internal review more, because that's going to be the battleground of any future appeal. It should, for owners, on the flip side, logically in the first tier tribunal, it should make their position easier, because the nature of the first tier tribunal up until now, when they were dealing with matters de novo, was that by the time you got the first tier tribunal, you found that a nomination that was pretty thin when it came in and got a bit thicker and a bit better by internal review. By the time you got to the first tier tribunal, there was loads of evidence about why something was realistic to think. And certainly I've sat in hearings where suddenly the third parties have got a chef and he's talking about what he's going to do and spin the pub around and turn it into a sort of gastronomic adventure. So that it had become common for third party nominator evidence to become stronger, let's put it as neutrally as possible, during the FTT stage, and that didn't happen now following Newton. But as I say, that's an issue to be thinking about. Now, here we go. The English Devolution and Community Empowerment Bill. It's still, that's the current position in terms of House of Commons and the House of Lords. The ACV provisions of this new act are all in Schedule 29. And as I say, as I'm implying here, this does turn things upside down. I have put revolution in the title of this. There are significant changes that have real impact. So let's talk about those. As I say, it inserts into the Act a new Section 86 through to 86Z6. It's that many new sections. It is an insertion because it's not changing the regime in Wales. So it's a new regime in England only. And then everything that is the current regime is being redrafted with insertions specific to Wales. So the existing provisions will all be amended to refer to Wales only. A headline change that people have taken very seriously, and I'm not sure it's the most important myself, is the change to the definition, which is the introduction of the concept of economic well-being into the definition. So previously we were talking about social well-being, now we're talking about economic and social well-being. And that's going to be in the new section 86B. 86B will be the new section 88. So less memorable again for me. There we go. What will economic well-being do? Well, I'm not sure it will do very much. It certainly will allow for businesses to be applied for listing. I know there's been a question about that amongst ahead of today's webinar. So it could be factories, it could be shops. I mean, we were already listing businesses, we were listing pubs, we were listing village shops and post offices, but I guess it could go beyond that now to shops that don't have that quite so obviously community value. So that's what it appears to do. There's also an addition to in section 86B, at the very bottom of 86B3, which is specific to those features of a sporting ACV. Oh, that's the first time I've said that. It's coming. That are supportive of the sporting ACV. So that's a very specific provision that appears to be, I've heard it references basically a car park provision. It's going to make sure you've got your football ground car park, but I think club houses, things like that would be captured by that. And then it also removes the recent past provision that we talked about earlier that was in 86.2a. And if I just take us into that, here's this new section 86b. I've highlighted for you where economics gets dropped in. I've put in just to show you where the deletion has happened for recent past. And then it's my emphasis and underlining in that food subsection 3. I'll just read it for the purposes of everyone. For the purposes of this chapter, but subject to regulations under subsection 4, a building or other land in a local authority's area is land of community value if, in the opinion of the authority, an actual current use of the building or other land provides support for the use of other land as a sporting asset of community value. And that sporting asset is defined under section 86C. We're going to get on sporting assets of community value. I know they're very important to people. I've seen people asking questions about them already. We'll get onto that. But that's just the first mention of it here. So that's the new section 88, as it were. That's the battleground section. There's a few other skirmishes that are going to happen in other parts of the bill, but certainly that's the parallel to 88 that I've already talked about. I suppose I will just say that support thing, what's that going to do? Is that hugely relevant? I've already talked to you earlier about salami slicing. Now, the current regime doesn't allow you to just drop off bits. So would that car park at the sports pitch be caught anyway by that concept? I do wonder what the practical impact of section 86B3 will be. Okay. Reads on review. So this is again bringing in new things. We've got things I want to highlight to you are here. That the removal from lists must be reasoned. That is now a statutory provision. Now your reasons you're probably going to want them anyway, but it's statutorily required. And when you are removing, the removal doesn't kick in until 6 months after you've given notice of removal. So I contrast that here with the current regs. Reg 2 is the one that gives you the powers and authority to stay aware of ACV situations in your area, and if you become aware of something not being an ACV anymore, you can amend the list and remove it. That provision is immediate, and it has been used. I've advised councils that had to use it immediately. Say, actually, no, that's changed, we better remove it. That is in contrast with how this is drafted currently, because it appears to be drafted under 86F to be, no, there will always be 6 months grace if you're going to remove it. That's how I read it on a clean reading. And what's interesting about that is that's 86F with the removal. The 86F removal in the new regime is all about notices. It's about how them to be served. It doesn't actually frame the test for why you would remove. And I contrast that again with Reg 2, the current system, which is very plain. It says, this is why you would remove. Now think about it. The new act, as I read the new provisions within the bill, as I read them, I can't see how it's framing that. I'm assuming that test is going to be basically the same. Is that going to be in regulation? But it's not apparent from 86F what it is. It should be, well, this hasn't been, this isn't the ACV anymore, which is what Reg 2 did. And it's probably going to be that. But as I note in the sub-bullet, Section 86H is the review provision, and it says, if if on review of a nomination you decide that shouldn't have been listed, you remove it. But it doesn't say you remove it immediately. And 86F seems to be saying that there's a 6-month grace period. So does that mean, application comes in, something gets listed, I as a landowner internally review it, and that's all dealt with within 2 months, but my asset still stays on the list for another 6 months? That, I think, is what the plain reading of the Act seems to say. It's unclear to me, but I would be highlighting that seems to be what it's doing. Anyway, in that second bullet, owners have their rights to seek internal reviews, and they'll have them for both asset security value and supporting assets. That makes sense. That's what we'd expect. The new thing, nominators, the third-party nominating group, will have the right to seek a review. So that didn't exist before. If you, as I showed you in that flowchart earlier, if you as a nominator have your nomination reviewed, currently that's the end of it. Not anymore. There will be a third-party right of appeal to review. There will be new regulations that will govern the appeals. That's unsurprising. The 2012 regulations are very specific to the current system. There are going to be new regulations. It has been said in voluntary, and third parties will have a right of appeal to the FTT. I think that's right. That's how I read the bill currently, but it's not utterly clear. It just refers us again to the fact that the regs will deal with appeals. But it is reasonable to assume from the language of 86H that that's right. When those regs come in, that right of appeal to the first tribunal will be both for the nominator and for the landowner. And then again, I note again 86H on reviews, pointing at that reasoning requirement. Now, in my experience, most reviews have had reasoning to some greater or lesser extent, but that is explicitly there now, that you will have to be giving those reasons. The right to buy. Here we are. So the right to bid will become the right to buy, or the first refusal. This is enacts a right to buy following the owner giving notice of the intention to enter a disposal. That's what might be known as an 86M notice. And I highlight for you, as if you're in local authority work, that there are 2 whole sections full of various notice obligations that stem from that notice to the local authority. So the local authority receives notice from the owner, and then you as local authority have various duties under 86Q and 86R. The nominating party, and you'll see I've taken that definite article and run with it, nominating party then becomes what's referred to as a preferred community buyer. So they have, if they give their notice, so they are in pole position. And that is something that I also think is probably going to be something you want to make aware of to applicants through your application forms. That if you're successful, you will be the primary engagement point for this going forward. It's not like the old system where you're just listing stuff and then making it available to the community to try and pursue. You will become the preferred community buyer. 86P has a system for when that preferred community buyer either doesn't take up the option to be the community buyer or falls by the wayside. There's the provisions under 86P. They're quite detailed. And then the upthought of the right to buy, again, creates for the owner an 18-month period to sell on after they've gone through the process. So a bit like we talked about the protected period under the current system, there will be that same thing here of 18 months. Okay. Right, what happens then once we've gone to our world of preferred community buyers? Well, that's where you as a local authority are going to now become many, many different things. So you will have an obligation as a local authority to facilitate a joint meeting. So it's not to make a joint meeting happen, not to introduce them to each other. It's not even to hold separate meetings. It's for you to facilitate a joint meeting with the owner and that preferred community buyer. That then begins a negotiation period of 8 weeks. And if that doesn't lead to an agreed price, then the local authority has the obligation to appoint and pay for the independent valuer who will determine market value. And they will do that within 8 weeks. And there are various provisions in 86T. It's an extended section about how that process works and how the independent valuer engages with the parties to understand their valuations and how he or she notifies the parties of his or her valuation. And then, independent valuer, And if we got a good RICs in the council, can we use them? No, you can't. Fortunately, Section 86T makes it clear that independent valuer will be a district valuer or evaluation officer or an independent valuer as described by the forthcoming regulations. Maybe the regulations will allow you to use an appropriately acting independently minded internal employee, but I don't think so. So there's another implication for councils and their budgets. The moratorium period, i.e. the period during which the party has the right to get on with making a bid, as opposed to the delay of sale, because it's not a delay of sale per se, it's the right to get on and buy, is extended from 6 to 12 months. And that's been pushed for strongly by those advocating for the regime, because they just say, well, 6 months has proved not to be good enough. And there's a lot of sense there, I can see that. So just in terms of, then we have this concept of progress requirements. So because we will now have this 12-month period, there are progress points at 6 months and 12 months where the local authority will have potentially an obligation to carry out a review of how the nominating preferred buyer is progressing with their attempt to purchase. It's quite complicated, and that's that fourth bullet point from the top. It is worth a close read of the sections, because the hard window is 6 months and 12 months. You as a owner, if you say, well, I want to know that they're getting on with this because they're, it's taking a year up, then you can put in your request for a review, progress review, before 6 months, at 2 months in, but it will only happen at 6 months. But also the Act is very clear that it only happens at 6 months. So the way, if you plainly read the Act, you can't put it in at 5 months, and you can't put your request in at 5 months and 3 weeks, because that's not giving the council 2 weeks within to carry out the review. And it doesn't say you can do that progress review after 6 months. It's 6 months and 12 months. Whether that will actually function that way seems odd to me, but it's very specific. As I say, but also if you're a local authority, you've only got 2 weeks to carry out that progress review. There will hopefully be assistance within the regulations. As I say, that's something that's provided for about how to do that and what are the key markers, the progress requirements, what those milestones will be. But it's not clear yet. And then here, the progress report thing, and here I'm sort of burying the lead a little bit. The sporting ACVs, they have a different progress review window. I don't know what particular, where they have 10,000 plus seats, sorry. I'm not sure what particular law being led to that, but there's a very specific provision for 10,000 plus seat stadiums to have a shorter progress window. Okay, but that's where it is. And then, of course, we can see also there will be new compensation provisions apparently through the regs as well. Right. Okay, here we go. Sporting ACVs. A new beast enters the jungle. So, the headline is, under 86C, that local sporting facilities will automatically be indefinite sporting ACVs. So that doesn't time out. That's what I mean. The indefinite, once you're on the sporting ACV list, you don't go anywhere. We're going to get onto what it means, local sport facilities, but that's the headline people have referred to. You've got your local sporting facilities. I've seen some questions already. We've got local sporting facilities. What does this mean? What the Act does say, and when I read this the first time a few months ago, it gave me the willies, 6 months to do a survey of your area to identify SACVs. I don't know. I'm not sure what we're going to call them. I'm going to call them SACVs. I don't know what we're going to call them SACVs. I guess that will be part of my life in the next few years. But you're going to have to put together a list within 6 months. So previously a reactive process where things were brought to you, now local authorities are going to have to be proactively, at least on the sporting ACV, getting out there and doing it. There is the provision that the list must be reviewed every 5 years. There is an amendment from Baroness Taylor that becomes 10 years. And I know that has the support of the Local Government Association, quite rightly, saying, well, hold on, you are imposing all these new resource requirements on us. At least make it 10 years, not 5 years, that we have to keep going through this list. And I can see why a lot of people think, well, this list could be many entries, hundreds of entries long. I don't think it will be, so we'll get onto that in a moment. But it's caused real concern that. So there's that. The list must be reviewed every 5 years. And also, when you're dealing with an application anyway for any nominated ACV, you've got to stop and think, is it actually a sporting ACV? So, when you are preparing your reports or when you're preparing your flow diagrams for looking at how to deal with an application, which is spoiler, I'm telling you, I think as a local authority, you probably want to be starting to look at these things now. You're going to want to insert a sporting ACV stage. Have we done the sporting ACV check on that flow diagram? And then just to circle back around and give you their reference again to the fact that Section 86B3 is that supporting component provision. So it's things that support sporting ACVs under 86C are captured by 86B3. And I'm really sorry, I'm just saying number 86 endlessly. I know it's probably sounding like double Dutch, but that's how the new numbering works. Okay, what is a sporting ACV? And this is where I think it gets interesting. So, an ACV, a sporting ACV, if in the opinion of the local authority, it is a sports ground within Section 17 of the Safety of Sports Grounds Act 1975. What? Where's that come from? Forgive me, it feels a bit like somebody's done Control F sports grounds cross English law to try and find a definition. Because let's look at Section 17 of this 1975 Act. Sports ground means any place where sports or other competitive activities take place in the open air and where accommodation has been provided for spectators, consisting of artificial structures or of natural structures artificially modified for the purpose. This is why I think that the sporting ACV list is not going to be as big a thing as you thought it was going to be if you're in local authority work. Because that definition, firstly, what's it got to do with community value? As I say, it feels like we're just grasping for some time that we've talked about sports grounds in the law, and then we're going to apply a definition for it. Okay, is open air. Open air, great, fine. Bear that in mind. It's an and provision. And where there has been this provision of accommodation has been provided for spectators. So I think it seems to me clear to me it can't be that the structures have come to be used by spectators for spectating. It has to be that there was a mindful decision to create the structures for spectating, and that it's either structures or natural structures. Okay, so why do I think this is interesting? Let's take a trip, because we've been sat in this virtual room, so let's take a virtual trip. Welcome to Pendle Forest Sports Club. I live in Pendle currently. Everything in Pendle is branded with a witch. Not my taste. I think it's possibly a little bit distasteful, but there we are. Everything's got a witch on it. So that's Pendle Forest Sports Club. Right. Let's just have a look at what's there. We have a lovely pitch. That's a cricket pitch currently in the winter. It's a football pitch. You can see a scoreboard behind it, a structure. You can see the cricket barrier there. And then just under those trees, believe me when I tell you, you've got some banking. Let's see what's next. Below it, you've got another pitch. On this pitch, you can see this is laid out for football. So this is football year round. This is the primary pitch of the ground. You can see goalposts. You can see stands, a barrier that people could stand against. You can see what I would refer to as dugouts. And in the foreground of that picture, it may not be clear, but that's also got a downslope. It's got banking there. And then at one end of the ground, looking over the cricket pitch and then down onto this football pitch, we have a clubhouse in that sort of tasteful pea green. It's pea green, not sure it's tasteful, but there we are. And we have a clubhouse with, as you can see, windows looking onto, two windows looking onto the ground. There's some windows on the other side that, just to be clear, are looking sort of towards the ground. So those are the physical infrastructure we can see. There's also a few the containers where they stored, ground cutting equipment, that kind of thing. And then here's just a little summary of what you've got. So, is this a sporting ACV? I don't know, but let's just talk about some of the things that might engage. That banking, I can see an argument in front of a decision maker whether that banking is a structure or the ground form being made to provide provision for spectators. It's certainly open air. We've got that. Is that barrier? Can somebody say in litigation that barrier is a structure that facilitates spectators? So we've got some banking. That's interesting. We've got these barriers. We've got these two dugouts. Now, these dugouts are, I think they're classic, management dugouts. That's where your sub sit when it's pissing down the rain. But also, if you turn up there on a random Saturday and half the crowd are in there, and my wife pointed this out to me because she's often she's an avid follower of various of our kids' sports teams. That when she goes to places, those dugouts are often occupied by the spectators. So are those spectator structures? What about the clubhouse? You can stand inside that clubhouse and look out. Is that clubhouse being provided to facilitate spectators, or has it been provided as a clubhouse? So there are, within the application of the Section 75 definition, which, as I say, I think is a curious definition to apply, there are lots of options to litigate about that definition. So here is, I think, what you would say is a classic example of the kind of thing you'd expect to see a nomination, or you'd expect the local authority to have to take into account of as part of the sporting ACV review and consideration. It seems to me like a classic example. Not entirely clear to me at all that it would pass the test. I think arguably not at all. And of course, what do we do? Another point that is worthwhile, this is a 2-pitch situation, but if you go to kids football of a Saturday morning, or my daughter's rugby, you can go to a sports ground where maybe the club has one pitch that has spectator equipment, spectator structures, banking in the ground for people to stand on, but there's another 6 pitches that don't. Who are those going to be? Is the local authority's opinion? Are you as a local authority going to list all of them? Or are you going to list the thing that's got the clear spectator structure? And obviously, you'll remember Section 86B(3) was that supporting part as well. So when you're considering as local authority under the sporting ACV provisions, you're going to engage with that too. So I don't know. I've not got an answer for you, but I think firstly that definition is much narrower than people probably expect. I think that's worth knowing. It's important. And I think also it's not obvious to me that it would affect a whole lot of the stuff that you're used to expecting it to affect. So we're going to get onto questions shortly, but fundamental summary, certainly for those in local authority work, the new regime is, where there we have a local authority officer in the place of Atlas holding up the world. It is new burdens for local authorities, extensive new burdens. For you've got new burdens in the sporting ACV lists creation and maintenance. You have valuation burdens in terms of paying for it, finding valuers. You have a role in party mediation when there's a preferred buyer and a selling owner. You've got to get in there and facilitate at the very least. I've talked about it, the right to buy is a dramatic impact on the owner. It is forcing the sale to another private owner. Well, that is a significant impact for that private owner, but it will also be an impact for the local authority because rightly, I think, private owners are going to get, they're going to be much more engaged. I previously have advised on this often and said, it's the ACV regime, just let it go by. We can do it this way, or we avoid matters that way, or we can address it this way. I'm not going to be giving that advice anymore because it's enforcing your right to buy. So one would expect that if you're a local authority, you're going to be seized of asset owners who are much more engaged with the regime or more generally engaged. You get very engaged ones, but I think there's going to be a more general issue across the sector. And with that in mind, my strong advice is therefore that you probably need to start looking at your processes. I have encountered many different ACV application forms over the years. Some of them are better than others. You're going to want to, before this regime kicks in, think about those processes, think about those forms, think about how detailed they are in their questions, so that you have a real sense of what's actually going on. You will know that if you are a local authority, you've got prosecutorial duties, you've got particular burdens. So we look at the enforcement system in certain sectors and like, this can make somebody a criminal, so we have to be more careful. Well, we're looking at a sector where now we can alienate somebody from their property through forced sale. That should mean that your systems are just that much more rigorous, I think. And, for instance, as I said, you're going to make these nominated preferred buyers, so your forms are probably going to want to say to them when they're making a nomination, by the way, you now become the preferred buyer for this. Are you ready as a group for that? Have you thought about it? Or do you want to reconstitute your group in light of that? So, as I say, I put the word revolution in the title. I think it's fairly there because it is a dramatic change. The system, from my experience working in it, was not achieving what people thought it was going to achieve. That's a fair diagnosis, I think. My honest opinion was I thought that it might lead, therefore, after the election of the current government, that the system might wither or be removed. Turns out that's not the case. Turns out the governments are doubling down, and that's what we've got. We've got a new system coming that is new and dramatically different. So thank you all very much. I'm now just I've got some questions in the chat. I've got a few questions elsewhere from previous people that came in. Will the case law that we currently have still have meaning? Yes, I think it will do. I think the realistic provisions probably will do. I think they will still have relevance. We've got will professional stadiums be caught? Absolutely. I mean, there's that 10,000 seat provision. That's absolutely the case. And the current regime has caught professional stadiums. I acted on the Macron Stadium. What's it called now? It's probably not called Macron anymore. Changed the name, but the Bolton Stadium. I've acted on that a couple of times. Somebody's asking here in the chat about transitional provisions, and somebody asked earlier in a pre-question. There's nothing within the drafting currently of transitional. You'd think there would be transitional provisions as a matter of fact, but there currently isn't anything about that. We're expecting, I think, that the bill will come forward and finalise and be enacted within this year, but maybe not to the second half now that we're already into April. Just looking at, there we are. We've got Q&As as well. I'll just pull up some of the questions around beforehand because I know that people have very kindly put things in before, so let's just have a look at those as well. So somebody was asking about the removal provisions. As I think I've addressed earlier, Reg 2 was really clear on removal. The new section I'm not so keen on, I'm not so clear about. It's about notice, but there will be removal provisions. People are asking about staffing. That's the reason I'm giving this talk. That's why I'm really concerned for my local authority clients, because it is a real change that I think will have real impacts. As I said, the local government authority has engaged, and I know that there's a government-backed amendment in the House of Lords to change the 5-year review provisions to 10 years. So that's at least something. But frankly, as I think I've outlined already this afternoon, it's a lot of new stuff to be thinking about. I've had some questions here about private shops, and you can see that's what the new economic provision is doing. And then a very interesting question here I hadn't really thought about before, but it came up from somebody earlier. What are the implications for this on village greens, town and village greens? So the current system, I would say that the ACV regime is irrelevant to town and village greens because, the ACV is, as I've implied or stated pretty clearly, a fairly limited effect regime currently, and obviously town and village greens are a massively impactful limitation on land. But now we've got this right to buy. Yeah, I can see that the new system could have really significant impact on land that is already a TVG. I could see that there wouldn't be a point applying for a town and village green to become an ACV currently, but there might be under the new regime because obviously it's going to create this right to buy and be a preferred buyer in the future. I've had some questions specifically about, and I can see it in some of the chat as well. If we've got transition, if we've got a notice given, or we have some kind of notice period underway, and transaction underway when the new system comes in, what will happen? We don't have the transitional provisions yet. There must be, as a matter of fact. I mean, it's common sense, but I would note to you that what triggers being a relevant disposal is governed by the Act in very specific places now currently. So if you are looking at, there's the exceptions. I've obviously referred you to Section 95.5. I'd also take you to Reg 13. That's about basically if you agree to sell, then that disposal doesn't get caught by the moratorium. But more importantly, Schedule 3 of the current regulations, specifically Para 4, is about ongoing legally enforceable agreements, so options to buy, things like that. Those can be very relevant. And certainly if I was acting for a private client in this regard of trying to sell an asset owner, I'd be looking at those provisions, seeing what sort of structures, the agreements can be put together that, put me very clearly in a certain box under the current regime, hoping that will have effect as we look at the forthcoming regime. But as I say, there's nothing transitional yet, certainly not in the drafting. So somebody asked, well, on the status of nominating groups as preferred buyer under the right to buy, are the eligibility criteria for you can bid under the existing system being changed to reflect this? Because, and it's just somebody who knows their onions, the current system, a local community group has to have 21 local individuals, and you have to look at postcodes and you have to work out where they are. That's going to be in the regs, sort of a pop out, but that's the pop out the government's doing too. I'm not sure that would necessarily need to change. But yeah, we're going to see it in the regs. I wouldn't be surprised if the nominating provisions don't particularly change. But though they might need to expand them, because you don't want to be in a position where most of the preferred buyers are parish councils, because they're not that. It's not something a parish council is going to do, or have the wherewithal to deal with. Then somebody's asking very interestingly, I'm wondering how will all the mediation work, whereas at LA or even a parish council asset would be. Oh, okay. So do we need to have do we need to bring in a neighbouring local authority to act as an arbiter or mediator? So when I've used the word mediator, apologies, it certainly says you facilitate, you bring together, you try and help them. The real mediation will be the independent valuer. They've got the real sort of quasi-judicial function, so they have to be independent. And I guess that's why the Act provides, and the bill provides, that they will be truly independent, because they don't want that issue. It's a good question. I would think that even if there is a degree of, it is not unusual for, an estates department to have something that somebody else applies to have an ACV on, where you're the landowner. I would think that you could reasonably, in my experience, create the sort of internal checks and balances, Chinese walls, which I'm sure local authorities have experience of doing in other areas. But I don't think there's no provision, say, to bring in another councillor to deal with the application. I know it's very much is for you at this stage. Okay, and then somebody's asked about notes, and they won't be available as I said at the start. Somebody says, if it's possible to partially list an asset, as Gulliver's I referred to, what would be the point of that be if the asset can subsequently dispose off without needing to apply for the moratorium under the part listed exemption? Yeah, that's a question from Kate. That is the kit and caboodle. When I'm acting for private owners, I am desperately looking to get my asset partially listed to slip through that section 95 5E gap. If anyone of you on the call has worked for me before in this, and I know some of you will have done, I'm always looking for a 95 5E partial listing gap, because that seems to me certainly the best way to get a peep through the system. So yes, it is. Partial listing and looking to have something partially listed is, on the private client side of the work, a big thing. And that's certainly been the exception that I've been most commonly aware of. So you're quite right to spot it, and that's the point. The part list exemption is there. Okay, so that's the Q's and A's. That's for somebody else in the chat. Okay, somebody was asking, about the playing pitch strategy. When the council's playing pitch strategy, which lists all the local authority sports pitches regardless of ownership, fulfill this requirement? No, I don't think so, because the sporting ACV list is a statutorily defined list of what that will have that binding effect on somebody's land, and it will do so. So, firstly, it's of quite significant importance, and it requires the application of the Section 86C text as to what a sporting ACV is. And we just looked at that section from the 1975 Act that's going to be engrossed into the new Act. So, no, the list, and I'm not suggesting that it would be this simplistic, but to sort of rebrand a sporting would not work. I think you're going to have to look at each site individually to apply the statutory text correctly. Now, as an authority, you may have some relaxation about that if there's a lot of those assets owned by you. But if some of that playing sports ground, under the sporting ACV test are privately owned, then I think they would be very exercised if they felt that list was that would certainly lead to challenge. I would certainly support, I would be able to make arguments for a challenge on that basis. Also, the sports playing field strategy that any council, I don't know each individual council's playing pitches or what they're like, but as you can see from the application, I think of the 75 test, I think there's not going to be it'd be quite hard to find a great degree of overlap there, I think. I think it'd be quite a significant difference. So I'm not sure it would get you very far. It might, maybe it'd help you populate an initial list to look at. Okay, so yes, a few people have asked, yeah, the slides will be circulated. I understand from talking from our team in Kings that there will also be a recording of this. We're now coming up to 3:20. We've been through all the slides. I hope you found that useful. As I think I made sure, I think this is a significant change. If you're in local authority work, be mindful of the changes coming. I would suggest you try and get rid of them a bit, because you will be operating a significantly more burdensome regime, both upon you and upon the owners. So you are going to have much more concerned owners about this regime than those that you already deal with. So that's one point. You've got my slides. You'll have this recording to look back again. I hope it's been of assistance to you, and thanks very much for the attendances. I'm glad to see that we've managed to keep most people. So there we are. It's 3:20. Thank you for your time, and do feel free to leave the event as and when you're able to. Thanks very much.